Hi, first of all, thank you very much for tuning in to BIP Chat. I'm going to explain what that is, and also I'm going to be introducing you to a fabulous lady who is, well, she's a lawyer. She's a commercial lawyer. She's fractional general counsel, works a lot with entrepreneurs and scale-up businesses. And we're going to be talking about some very important stuff that is important to all of us. And I'm going to be taking notes as well. So before I do that, I'm going to just introduce, in case this is the first time you've listened in, to what BIP Chat's all about. So BIP stands for Business is Personal. And it's the juxtaposition of when somebody said to me once in a horrible meeting, Penny, I don't need to like you. It's business. It's not personal. And I thought, oh, this is going to be horrible. And I truly believe in a world where we've so disconnected emotionally from one another, technology's taken over our lives. Actually, business is very personal, and the people who thrive put that human touch into everything. The other thing I believe in with Thomas, we believe in very deeply, is that it is incredibly hard to find great experts. You can Google and you can find people on LinkedIn, and you might be able to get a little bit of a referral from someone. But how have they been validated? How do you know that these are good people? So we've built a community called Business is Personal 100, BIP 100, where we have spent the last 4.5 years looking for really brilliant people to join our community, and they can co-create, they can collaborate with one another, refer one another. But critically, it enables us to celebrate this person and introduce them to you, the listener. So today you're going to learn a little bit about how important it is to have some of your legal areas tighter. And thank you so much, Alexis Goldfinch. I'm going to remind you of that at the end. Alexis Goldfinch, thank you very much for joining us and giving me some of your time to share your wisdom. So before we start, it's always nice for people to know a little bit about your background, Alexis, because you now run your own business. So tell us your journey.
Yeah, hi, thank you so much, Penny. So I started my career at a big law firm called Fractional, where I spent many happy days and learned an awful lot. As part of that journey, I spent some time at some of the clients of the firm. So I've been in industry at places like PepsiCo and Barclays, Sony Computers, and Bank of America. So at that early stage, I got a great understanding of what it was like to be, within a client's organization. I later on set up and headed up a legal function at an AIM-listed management consultancy business called Alpha FMC, where I was the global head of legal. And then a couple of years ago, I decided to set up my own practice because I wanted to support entrepreneurs and scale-ups. I wanted to be within their business, advising them and doing it on a fractional basis. So for those of you who don't know the fractional term, doing it on a part-time basis, which benefits both the client because they may not have the need for someone on a full-time basis, and also my own personal kind of work and family commitments.
Yeah, that's wonderful. It's amazing. So when people do make these changes from working for large codes with all that wisdom and come in and suddenly enable the smaller business and the startups, etc., to start getting their hands on that expertise, which is so needed. Now, there was a huge list of things we could have talked about, but we decided that it would be a good idea to start with the foundations of where we all should start, which is what are our terms and conditions? And I bet you as a listener, you might be going, oh, terms and conditions, I don't need that. My clients trust me and we know each other really well. Well, listen in. It's not that arduous to create your T's and C's, but I think there are some things that you may have done that Alexis is going to mention, which aren't necessarily the clever way to do it. So we're going to talk about the 5 costly mistakes businesses can make with their terms and conditions, their T's and C's. So yes, Alexis, you've got a lot of experience in this and working with scale-ups and startups. Tell us a little bit why you see this as so important, and then we'll get on to these costly mistakes that people can make.
Yeah, so I feel that terms and conditions are one of the most crucial aspects of a client relationship, but actually it's one that's often overlooked. I don't really like the term T's and C's. I think it devalues that client contract because when you hear the word T's and C's mentioned, you often think of the small print on the back of a mobile phone contract rather than a fundamental contract within a business. So getting them right means that your business is on a really solid legal footing. It protects your revenue stream. It defines your client relationship. And then if things go wrong, it's, in my eyes, your first line of defense. So really important. Every business has clients. So if I was to pick one commercial contract that you should focus on, this is it. And terms and conditions is the phrase that's used quite loosely, hence why I'm using it today to try and make sure that listeners know what I'm talking about.
Yeah, it's good. And listening to you then, I was thinking, I guess it's really all these subscription businesses that have almost, like Apple and all sorts of things, that have almost devalued terms and conditions, because so many of us don't even bother reading them. We just glance through it, click, I agree. But I bet before that world, terms and conditions were absolute bedrock. Nobody would consider having a business without them.
Yeah, no, you're dead right. And actually, it reminds me of a fun fact. Virgin Media, quite a long time ago, put in their force majeure clause in their terms and conditions a line that said that if you'd read this far, they'd give you a free bottle or crate of wine, to test how many people actually read them. And yes, we all subscribe to lots of different antivirus protection software, lots of things every day, and just click that box. But when you're the business owner, it's so important to get this right.
So, Alexis, you mentioned that there are 5. You've sort of pulled out these 5, that the sort of things that we can all damage ourselves by doing wrong on these terms and conditions. What would you take us through those 5?
Okay, so to start off, many businesses' terms and conditions are incomplete, or they're not suited to the business's own business model. This happens because businesses often copy templates or take templates from the internet, or they copy their competitors' terms and conditions. They say, hey, we're offering the same service, so I'll just cross out their name and put in mine. Or they just haven't even got a formal contract in place with their end clients. So this is why you end up having incomplete or irrelevant terms in your terms of business.
Yeah, I can imagine a lot of people are thinking ChatGPT can create them now as well.
Yeah, exactly. It's another form of template creation today. But actually, it really is so important for a business to look at their own business model when creating their terms of business. So at best, it can lead to ambiguity with an end client. At worst, it can lead to a costly dispute. So to give kind of a simple example, you might be in the same line of business, but the business you've copied from offers a subscription model for its end customers, whereas you offer one-off services. So if you just copy and paste and there's an automatic renewal clause in there, your customer doesn't know what this relates to. It leads to ambiguity and or a dispute. Other times, if they're not drafted properly, the clauses may be vague. So take payment, for example. A draft that says you must pay the invoice promptly. What exactly does that mean? For me, it might mean within 7 days. For another person, within 60 days. So that's kind of what I mean. But also kind of at a deeper level, when you compare business models, one business may create the product and offer the service, completely organically to their end client, whereas another business may be heavily reliant on third-party subcontractors. And so sometimes I see businesses kind of over-promising or giving warranties to their end clients when they don't have the equivalent warranties from the subcontractors they use. So it ends up creating additional unnecessary risk for that business.
Oh, that is that's such good advice. Now, the next one I find really interesting, which is putting it in on unenforceable clauses. So this whole non-compliance legal requirement that we have when we are serving a client.
Yeah, so I see both kind of unfair and unenforceable clauses included, and then terms of business that don't actually comply with the laws of the country that you're operating in. So it goes back to kind of one of the risks of copying a competitor's template. You may copy from a business that's a UK-based business but has a presence in Spain. They
Right.
will reference Spanish consumer legislation or the Spanish code in their terms of business. And if you don't have any operations in Spain, you're kind of you're voluntarily submitting to laws that you know nothing about and that are irrelevant to your business.
Wow. Wow,
Um,
that's really interesting. So you have to create terms and conditions by territory.
Depending on, yeah, it depends on the arrangement, whether it's B2C or B2B
Mm.
world that you operate in. But you really need to be mindful of your own business operations when you're
Right.
preparing them. I often see as well businesses drafting quite one-sided terms.
Mm.
But if you are operating in the B2C world, there are quite strong consumer protection laws in place. And if you draft very one-sided terms of business, they may be struck out as unenforceable by the court.
Yeah,
Um,
amazing. That's very, very interesting. So now the next one is considering intellectual property rights, which is very, very interesting that because I see people creating IP over methodologies, not just product. So I can see why that is so important to make sure you've got that locked down, especially when working with clients. So tell me a little bit more about that.
Yeah, well, IP is a topic very close to my heart. It was one of the areas that I trained in, and it's an area that I see clients getting into a real pickle um, very regularly. So I today, clients when they're creating work, businesses when they're creating work for their end client, be it a logo, be it branding, be it software, be it a platform, they often, it's very ambiguous as to who owns what and the IP rights in that creation. So without a really strong IP clause, first of all, ownership may be ambiguous between the client and the service provider. In certain territories, the law automatically assumes that the entity that created the work will own the IP rights in it.
Right.
So, and then a business who is paying for said product may assume, well, I'm paying for it, so I must own the IP rights in it, and that's can come as a nasty surprise. So, without a clear, kind of effective statement as to ownership, who owns the IP rights, you can end up in a dispute over that.
Wow, that's fascinating. That is really interesting. I've got a friend whose daughter's working with Cambridge University. She's done a PhD, and it's quite interesting with what she's discovered and where that's going. And so, and I suppose that applies, when you hire a software developer to create something, or you're working with a marketing company to create, or you're working with a coach when you're working on a particular methodology for your business. I suppose are those the sort of scenarios?
Yes, exactly. And when you're, after you decide on who owns what, you also need to make sure that if you're the service provider, you can continue to run your business and service other clients, as well as delivering the end product for one particular client. So you can, without being clear on kind of A, ownership, and B, usage rights for an end client, you can end up getting allegations of copyright infringement from one client who thinks that they own all the rights in a work product, when in fact you really wanted to reserve the rights to use some, pre-existing templates or some materials you might reuse for another client. So, it can lead to disputes, unless you're really clear on IP.
Wow, this is fantastic. We've covered 3 of the areas that we really need to watch out for when we're creating our terms and conditions, and also how incredibly critical they are. And the 4th one out of the 5 is not limiting liability appropriately. Wow, I would love to learn more about what you mean by that.
Okay, so often I see clients forget to include or omit to include a liability cap. So what that means in reality is that a business may do a small low value piece of work for its end client, but if it doesn't cap its liability, it could find itself subject to a massive claim by the client if something goes wrong. That's
Wow.
completely disproportionate to the value of the initial project that they were instructed on.
Oh my
Um,
goodness. That's terrifying, actually. And you must have seen that happen.
yeah, oh, it happens all the time. And, you know, as a lawyer, a commercial contracts lawyer, it's the first thing you look for in a contract. But if you're not, if you're not a lawyer, you might, and it's not there, you might not know that you need to include one.
Wow. Yes,
Um,
because I sort of thought, well, I've got my what's it called? Can't even think of the name of it, the insurance policy against us being sued, but I'm surprised that they didn't force me to have terms and conditions.
Yeah, well, insurance, there's one point on insurance that I see clients get tripped up by, because they often limit their liability at the level of their insurance cover.
Mm,
But actually, many insurance policies work on a per event basis. So if one event causes claims by several of your clients, if you cap your liability at the total value of your policy, so if client A has a liability cap for 5 million because that's your insurance policy, and the same for clients, for all your clients,
mm.
if one event causes losses to multiple clients, then your total coverage for that one event is 5 million. But in fact,
Wow.
you've exposed yourself to 5 million across all your clients or multiple clients. So,
Mm.
you know, it's really important that businesses understand their insurance policies before deciding to link their liability to the insurance cover they think they have in place.
And liability can be advice that you've given, not just a tangible
Product.
service.
Yeah,
Yeah.
absolutely.
So somebody's taken some advice and it's been really destructive to their business or life.
Yeah, and that's and it's also very important to then, if you are giving advice, then to kind of carve out your liability and have appropriate exclusions if you don't want it, for example, shared with third parties or relied on by someone else that's not your end client. So it's very important to kind of scope out what your end client can do with that advice.
Wow, that's incredible. I think that one's the one that scared me the most. So, finally, number 5, no dispute resolution, cause or use foreign laws or courts. Tell me about that.
Yeah, so sometimes there will be disputes, and clients just at the outset think they're going to dance into the sunset and never envisage that there would be a dispute. And I see clients omit to include some sort of dispute resolution process, which would lead them in a scenario that if they can't resolve the dispute kind of very informally, that the next step is going to court proceedings, which isn't always the best outcome for businesses. So, you know, for example, a business may choose to include a mediation or arbitration clause, which would help them avoid costly litigation. Linked to that, I mentioned foreign courts. And again, that's something I see in particular where clients have taken a template off the internet or copied their competitors. They they find that they've got a governing law clause, which is, for example, the states of Delaware, and the courts in California might hear a dispute. And when I ask them, or kind of comment that it's quite an interesting choice, and ask them how they came to that outcome, they don't know how, and they've just copied and pasted it. And this, if you imagine if you're a European-based or a UK-based business with no presence in the US, the implication of having those US governing law and jurisdiction clause is massive. If there's a dispute, you first of all will have to get lawyers in the US to manage the case. Secondly, the courts in California will need to hear the dispute, which means you and your management team and your perhaps local lawyers and your US lawyers all find yourself decamped to California for the duration of the case.
Oh my God.
So it's just so disruptive and unnecessarily costly. So that's kind of one of the horror stories I've seen in the past.
God, this is incredible. It's got my heart racing like crazy listening to this. I'm sure it will have done it to you as a listener, because I think, as I say, we can be very, we can really devalue the importance of T's and C's. I think Alexis has just got us as a client. And I know this isn't the only area of law that you work in, but I can see why this is such a fundamental start. And when you work with a client and you look through this, you must get to know so much about their business model. It's a really interesting starting point, I guess.
Absolutely. It needn't be a daunting task. It needn't be, it's not the greatest task of all, but it can really set you up on a solid foundation. You end up sleeping at night, knowing that you've had a conversation and done kind of a fairly rigorous review of the risks you see your business facing, any problems. If you're an experienced business owner, you'd be able to think back to the problems that you might have had with your customers. Maybe they've ended up in litigation, or maybe they've just ended up in an awkward conversation. And by incorporating those areas in your terms of business, it really is a powerful weapon. As I said at the outset, it's your first line of defense if something goes wrong, but ultimately it's protecting your revenue stream and should be really reflective of the type of client relationship that you want with your clients.
Yeah, I can really see that. I mean, and also it's protecting the client as well, because isn't it? It's
yeah, absolutely.
It's all round protection, which is so powerful. And I like the fact that you say it's not too daunting, because you've got that experience to be able to take somebody through that journey. I've absolutely loved it, and what amazing wisdom to share. And I hope you as a listener have been able to enjoy this and take notes and listen to it again. But ultimately, if you would like me to connect you to Alexis, I would be delighted to, myself or Thomas, or you can look her up yourself on LinkedIn, Alexis Goldfinch, and enjoy the show notes when you're watching this, whether you're watching it on YouTube and you can see us both, or whether you're listening or you're walking the dog or driving a car or something like that. And I hope this has been a great help for you, having access to Alexis as an expert for the last half an hour. That's been a fantastic conversation. Thank you so much, Alexis. I really appreciate it.
Thank you, Penny, for having me.